20 states sue Trump over new public benefits restrictions, legal challenge explained. In a bold move that has sparked intense debate, **20 states, including Washington, have united to sue the Trump administration over what they call an overreach of power in restricting access to public benefits**. This isn't just a legal battle, it's a clash over fundamental rights and the role of the federal government in determining who gets essential services like healthcare, education, and social support. But here's where it gets controversial. The Trump administration is demanding immigration and citizenship records from benefit recipients, regardless of their legal status, a move that has raised alarms about fairness and constitutionality. Washington State Attorney General Nick Brown has been vocal about the issue, arguing that these new rules threaten to cut off critical services for families and vulnerable communities. In a January 2025 press conference, Brown highlighted the lawsuit filed against President Trump's executive order to eliminate birthright citizenship, a move that many see as part of a broader crackdown on immigration. Now, this latest legal challenge focuses on the administration's new federal rules, which took effect earlier this month, and which Brown claims violate the Constitution by imposing conditions without proper notice or consent. The coalition of states is urging the courts to step in and halt these changes, but this isn't just a legal technicality, it's a deeply emotional issue. For many, it's about protecting the most vulnerable among us. For others, it's about enforcing the rule of law and ensuring public resources are used responsibly. And this is the part most people miss. The debate isn't just about immigration policy, it's about the balance of power between federal and state governments and the rights of individuals to access basic services without undue interference. Is this a necessary measure to protect national interests, or an unconstitutional overreach that harms those in need? The answer depends on who you ask, and that's precisely why this case is so divisive. As the legal battle unfolds, one thing is clear: the outcome will have far-reaching implications for millions of Americans. What do you think? Is the Trump administration justified in its actions, or are these states right to fight back? Let us know in the comments. This is a conversation that needs your voice. Lawsuit challenges Trump-era restrictions on Head Start for undocumented kids. In a bold move that could reshape access to essential services for countless families, a coalition of 21 Democratic state attorneys general has filed a lawsuit challenging recent federal restrictions on programs like Head Start. These restrictions, imposed by the Trump administration, target immigrants residing in the U.S. without legal status, limiting their ability to benefit from critical community-level initiatives such as early childhood education, health clinics, and adult learning opportunities. At stake is not just the future of these programs but also the well-being of thousands of children and families who rely on them. The lawsuit, spearheaded by New York Attorney General Letitia James, argues that the administration failed to adhere to proper rulemaking procedures and neglected to provide adequate notice about the conditions being placed on federal funding. Beyond procedural concerns, their complaint warns that these changes could have devastating consequences. These programs work because they are open, accessible, and grounded in compassion, James said in a statement. This is a baseless attack on some of our country's most effective and inclusive public programs, and we will not let it stand. But here's where it gets controversial. The new rules effectively reverse a decades-old interpretation of federal laws regarding immigrant access to services, which dates back to the Clinton era. Announced earlier this month by multiple federal agencies, including the Department of Health and Human Services, the Education Department, the Department of Labor, and the Department of Justice, the restrictions introduce requirements for verifying immigration status. This shift raises questions about feasibility and fairness. For instance, how can programs serving vulnerable populations implement such measures without compromising their mission? One of the most affected programs is Head Start, a federally funded preschool initiative designed to support children from low-income families, including those experiencing homelessness or living in poverty. Historically, Head Start has never required participants to prove their immigration status. The program offers developmental therapy, childcare, and early education, creating a foundation for young learners to thrive. However, under the new guidelines, providers would need to screen participants for documentation, a task many say they lack the resources to perform. And this is the part most people miss: implementing these checks isn't just burdensome, it could cripple entire programs. As the lawsuit points out, it is likely that for some programs, the costs of compliance will be so high as to lead to the program's closure. Many Head Start providers operate on extremely tight budgets, often teetering on the edge of sustainability. Adding administrative hurdles may push smaller organizations over the brink, leaving both immigrant and non-immigrant families without access to vital services. The ripple effects extend beyond Head Start. Other community-based programs, such as mental health services in schools, crisis hotlines, and substance use disorder treatment centers, face similar challenges. These programs serve diverse populations, including U.S. citizens from low-income backgrounds who depend on them for health and educational support. Critics argue that imposing immigration-related barriers risks undermining the quality of care available to everyone. So, what does this mean for the future? Will these restrictions withstand legal scrutiny, or will they be overturned? And more importantly, how do we balance national policies with the needs of vulnerable communities? These are tough questions that deserve thoughtful discussion. Do you think these rule changes protect taxpayer interests, or do they unfairly penalize families in need? Share your thoughts in the comments below, we'd love to hear from you. DEM AGs sue Trump administration over cuts to Head Start and Medicaid. In a bold move, a coalition of 21 Democratic attorneys general is taking legal action against the Trump administration over its latest policy targeting immigrants' access to critical services like Head Start and healthcare. This contentious decision threatens to disrupt the lives of millions of children and their families, many of whom are U.S. citizens. But here's where it gets controversial. The Trump administration claims that this policy will save taxpayers billions of dollars. Let's dive deeper into this complex issue. The Democratic AGs argue that the new policy jeopardizes essential services for vulnerable populations. Head Start, a program that supports over 700,000 children and pregnant women annually, is at risk. This program helps low-income families prepare their kids for school, but now, its future is uncertain. New York Attorney General Letitia James, a vocal critic of President Trump, passionately stated that the federal government is suddenly pulling the rug from under us, jeopardizing vital services like cancer screenings, early childhood education, and primary care. She vows to fight against what she sees as a heartless attack on inclusive public programs. The AGs seek a federal judge's intervention to halt the rule change before any services are lost. They contend that enforcing citizenship checks could be overly burdensome for small service providers, possibly leading to closures to avoid accidental violations of the new rules. And this is the part most people miss: the potential ripple effects of these changes extend beyond direct service recipients to entire communities. The Trump administration, however, asserts that non-citizens have never been entitled to these services, and the reinterpretation will save taxpayers $40 billion. The Health and Human Services Secretary, Robert F. Kennedy Jr., declared on July 10 that this action restores integrity to federal programs, enforces the rule of law, and prioritizes resources for American citizens. Yet, advocates question the impact on mixed-status households, where eligibility for services may become unclear. Head Start alone could see $374 million redirected, potentially benefiting other Americans, according to the Health and Human Services Department. These moves align with Trump's broader immigration crackdown, which includes tighter border control and increased deportations. The president is also exploring ways to eliminate birthright citizenship for children born to immigrant families, further restricting access to programs like Head Start. Joining New York in the lawsuit are attorneys general from Arizona, California, Colorado, Connecticut, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New Mexico, Oregon, Rhode Island, Vermont, Washington, Wisconsin, and the District of Columbia. The coalition writes, for the first time, millions of people are being asked to prove their citizenship before accessing basic services. This lawsuit adds to a growing list of legal battles between these attorneys general and the Trump administration over issues like federal funding cuts, research grant withholdings, student visa modifications, and the proposed end to birthright citizenship. The stage is set for a heated debate over the rights of immigrants and the role of government in providing essential services. What do you think? Is the administration's stance justified, Or is it a step backward in terms of inclusivity and compassion? Share your thoughts in the comments.